I'm Scott Ford at Ford Richardson, and I'm delighted to have with me several of our attorneys from our various offices. Specifically, we've got Brian McNamara, one of our partners in Roanoke, Virginia, Justin Ward, a partner with me here in Richmond, Emily Pappas, an associate with us in our newest office in Raleigh, North Carolina. But we are Ford Richardson offices in Richmond, Roanoke, Fairfax, Virginia Beach, DC, and now Raleigh. This is a very interesting topic, and I appreciate all of you that have joined in. I think by last count that I saw this morning, there were 243 registered attendees. We do encourage questions, and we will take questions as they come in, and certainly feel free to ask many questions. And again, we'll address those as we move through today's presentation. I want to especially thank Emily, who took a leadership role with the written material today. And this presentation, I think many of you are familiar with this very unfortunate set of facts dealing with the school teacher, Abigail Zwerner. Case actually received some national attention because of the peculiarity of the case, and was tried over the course of days in the end of in October leading into November, resulted in a judgment of $10 million. But today we're going to talk about the implications of that case, what may be happening next, talk about the case, and how that case may impact the state of the law in Virginia and perhaps nationally. So without further ado, let's get right into it, and I'll kick it over to Emily.
Hi, thank you, Scott, and thank you everyone else for being here. So we are going to start just with a quick content warning. Today we will be discussing obviously a case that involves a shooting. There are references to child neglect/abuse, gun violence in schools and employment settings, mentions of physical violence, non-graphic photos of a crime scene, a short video clip, which John will start after this slide, and a brief mention of suicide in another case.
The teacher shot by a 6-year-old student takes the stand today and relives her ordeal.
I thought I was dying.
Abby Zwerner told the jury that she thought this was the end when she was shot. She was on her way to heaven.
My next memory is I see two coworkers around me and I process that I'm hurt and they're putting pressure on where I'm hurt.
The teacher's testimony comes one day after chilling police body cam video was played in the Virginia courtroom. The bullet passed through Abby's hand and lodged in her chest, where it remains to this day. She said 2 days before she was shot, she had a nasty encounter with the student.
He slammed my phone to the ground.
And it broke the screen protector.
Yes.
The teacher said the student was suspended for a day. She says the student and his mother apologized for slamming the phone, and he was allowed to return to school. That's when he shot her.
Is that why you lifted your hand? Did you know what was about to happen?
Yes.
28-year-old Abby is suing the former assistant principal of her school. Ebony Parker allegedly failed to act after 4 different people went to her with concerns that the student had brought this gun to school. The police body cam video shows Parker in the school office right after the shooting. Attorneys for the assistant principal questioned whether Abby was really as badly hurt in the shooting as she claims.
So, to go through some of the facts of this case, Abigail Zwerner was a 25-year-old first grade teacher at Rich Neck Elementary School in Newport News. The assistant principal was Dr. Ebony Parker, and she is the sole defendant in the civil case that just took place. The child who ultimately shot Ms. Zwerner is unnamed. He was 6 years old at the time. He will be referred to as today and in most of the court documents and media reports as the child or the student. There were a lot of issues with this child when he was in kindergarten the year prior. He showed physical aggression towards teachers and counselors. At one point, he had bragged about having access to his mother's marijuana and getting high off of it, which prompted a report to CPS. And then there was an incident, a specific incident during his kindergarten school year where he went up behind his teacher while she was sitting down and put his arm around her throat to choke her. TA pulled him off the teacher and removed him from the classroom, but the child was again returned to the class because there was reportedly no administration available to deal with the situation. And the assistant principal, Dr. Parker, didn't seem to take the situation very seriously, and it wasn't until the kindergarten teacher threatened to leave if the child wasn't removed that the child was permanently removed from his kindergarten class. Administration had recommended the child be sent back to preschool at another school, but it's not really clear where he went, only that he never completed kindergarten and his behavioral issues were not addressed. He was then placed in Miss Werner's first grade class for the 2022-2023 school year, despite having not completed kindergarten. He was described as reckless, physically aggressive. He used profanities with teachers. He had choked another student at one point. And due to his ongoing behavioral problems, there were several meetings between Miss Werner, the principal, the assistant principal, a reading specialist named Miss Kovacs, and the child's mother. Ultimately, the child's school hours were reduced to only an hour and 40 minutes each morning, and then he left. And one of his parents had to sit with him in his class, even though the father had a documented criminal record and the mother was a habitual drug user. But no background check was ever run on them, and other parents were not made aware that this child's parents would be in the class with their children. There was no individualized education program, IEP, that was ever implemented, and the child was never considered or recommended for an alternative school placement or a classroom for emotionally disturbed children. Unsurprisingly, his behavioral issues continued. And there was an incident on January 4th of 2023, which was mentioned during the video, where he grabbed Miss Werner's phone during reading time, held it above his head while staring at her, and then slammed it onto the ground, cracking the screen. The child then said, "I'm never coming back to your room again, you bitch." He was ultimately suspended for 1 day, and January 6th of 2023, which was the date of the shooting, was the child's first day back from school after his suspension. He immediately showed signs of aggression, including threatening to beat up a kindergarten student that day. And just before noon, Ms. Werner went to Dr. Parker's office and told her that the child was in a violent mood. Dr. Parker did not respond, didn't look up from her computer, or acknowledge Ms. Werner's presence in any way. Shortly thereafter, 2 students ran up to Miss Kovacs, the reading specialist, saying that the child had a gun in his backpack. Miss Kovacs went to Miss Werner's classroom, asked the child if he had a gun. He said no, but wouldn't let her look in his backpack. Miss Kovacs then reported this to Dr. Parker before recess, but Dr. Parker again took no action, asked no questions, didn't appear particularly concerned. At recess, Miss Werner texted Miss Kovacs to say that before recess, she had seen the child put on an oversized sweatshirt and then rummage around in his backpack and then put his hands in his pockets and not remove them. And so during recess, Miss Kovacs searched the child's backpack and found nothing. And she told this to Dr. Parker and expressed concern that the child might have put something in his pockets. And Dr. Parker said he has little pockets and took no action. Then during recess, the child was seen running behind a rock with another first grade student. And afterwards, the other first grade teacher, Miss West, asked this other student what was going on. And the other student appeared visibly scared and was shaking. He said the child would hurt him if he told her. And then he admitted that the child had a gun and bullets. Miss West obviously called the administration office. She told the receptionist what the child had told her. The receptionist told Dr. Parker, whose response was that the child's backpack had already been searched. And then there was also a counselor that spoke with the student who had been shown the gun. And this counselor, Mr. Rawls, also told Dr. Parker, and so this was the third person to tell Dr. Parker, and the fourth time this had been reported within just about 2 hours. And again, no action was taken. The school policy said that principals and school security officers could search the students and their property if there was a reasonable suspicion to do so. So Dr. Parker had the authority to conduct a search, but she chose not to. About 20 minutes after Mr. Rawls, the counselor, had made his report to Dr. Parker, the child removed his hands from his pockets for the first time since before recess and shot Miss Werner from about 6 feet away. A bullet went through her hand and lodged in her chest. And understandably, the other children in the classroom fled. They went across the hall to Miss West's office. The child actually tried to shoot again, but the gun was jammed, so he wasn't able to. Dr. Parker and the principal's response to the shooting was unfortunately just as disappointing as their inaction prior to the incident. Another woman ran into the administration office and said that somebody had been shot, and Dr. Parker and Principal Foster went into their own offices and closed their doors, leaving the receptionist, a young boy, and a grandmother of another student at the school out in the reception area. It was the receptionist who then called 911 and announced a lockdown over the PA system. And the grandmother who was in there started, taking care of this little boy who was very scared. She told him to hide. Miss Werner actually then came into the office bleeding from her gunshot wound and passed out in front of the principal's door. And it was the grandmother who held a rag to Miss Werner's wounds to slow the bleeding until paramedics arrived. And you could kind of see in that video, I'm not sure if it was the principal or the assistant principal, you could see somebody opening their door and looking out and then going back into their office. So it was a really odd and disappointing response. That said, according to the grand jury report, the police's response was prompt, efficient, and admirable. The first officers arrived within 3 minutes of the call, but they couldn't get into the school because the front doors were locked and the buzzer system wasn't working. There were also a lot of security issues at the school, outside of this specific incident. They tried yelling and banging on the door and ultimately tried shooting the glass out, but they couldn't get in until a custodian roaming the halls saw them and let them in. There were, again, continued issues after the fact with the school and the public school system's response to the incident. The shooting occurred around 2 p.m., but the school didn't contact any of the parents until after dinner time that evening, and most parents found out about the shooting from the news or social media, and it was chaos when they arrived to try to pick up their kids. The school also declined to transfer most of the students who requested to be transferred after the incident due to, having trauma from this incident. And there was also issues with the documentation of the incident and of the child's disciplinary records. When a search warrant was executed, the records were found severely lacking. They didn't mention this incident in 2021 where he choked his teacher and then didn't finish the school year as a result. All the incident forms and referral forms completed by the kindergarten teacher and turned into administration were missing. And there were supposedly 2 physical files at the school pertaining to the child, one in Ms. Werner's classroom and one in the main office, but both were missing despite files for all the other students being accounted for. And ultimately, one of those files was found in the car of the director of elementary school leadership in Newport News, her vehicle. She said she didn't know how it got there. And when she did finally turn it over, it was missing all the child's disciplinary records. Ultimately, a grand jury was impaneled in September of 2023. They found that Dr. Parker was criminally liable for child neglect. Charges weren't brought against the child, but they were brought against his mother, who is serving a prison sentence for state charges of felony child neglect, and she's also currently serving 21 months of a related federal weapons charge. Dr. Parker's criminal trial is anticipated to start in May of 2026, and she is currently facing 8 felony counts, each punishable by up to 5 years in prison. So I will turn it over to Brian at this time, unless there are any questions in the interim.
That's wonderful, and a good recitation of the facts that you wouldn't know by simply seeing what's being released on the media. So thank you, Emily.
Absolutely.
Brian, you want to chat about the civil suit and the plea and bar, and give a good discussion of what that means. What's a plea and bar?
Very good. Good afternoon to everybody, and thank you for coming. The next thing that happened that's relevant to us today, of course, is that the teacher, Mrs. Werner, filed a complaint that's about 20 pages in length and raises a number of different causes of action against a number of different people. So first, I'll just mention the people that were sued were the Newport News School Board itself, the superintendent of schools, Dr. George Parker III, the assistant principal who has whose name factored so prominently in Emily's recitation of those facts in a very unfortunate way, and Brianna Foster Newton, who was the principal, who did not come off much better, I guess, in the fact recitation. There were different counts that were asserted against different people, sort of in combination. One thing that was interesting is that every single cause of action that they raised it by pleading a duty, and then they just slapped negligent, grossly negligent, and reckless breach all in one against a single duty of care. So the first count was addressed to the school board and Ebony Parker, just generally of a breach of an assumed duty of care, and that was about assurances that were allegedly made by Ebony Parker that she did various things that would have increased the overall safety of the situation that she failed to do, and the school board was obviously brought into those as her employer who negligently, or as her employer in a straight up just you employed her, you're responsible, respondeat superior basis. Is there a question?
Question from Sarah. And the question, Brian, is, are there any charges pending against the school system, other personnel, for what appears to be tampering with evidence on the child's previous incidents of violent behavior?
Shockingly, Sarah Rowe asks an excellent question. That's pretty much a norm here. So yeah, that's a great question, and there's nothing like that been reported yet. There's certainly no reason that something of that sort couldn't wind up happening. And for it to be sort of the last thing that happens in this big row of dominoes would not be shocking. It would probably be a longer investigation and a fairly elaborate grand jury presentment before something like that came down. So I don't think we're outside of the window to see that occur, but they haven't shown that card yet.
The grand jury report, who was convened in 2023, the grand jury did take significant issue with the superintendent who, or excuse me, it wasn't the superintendent, it was the director of education leadership in Newport News. They took a big issue with the fact that she didn't produce those files, and files were missing, and one was in her car and didn't know how it got there. And they said they thought that could have constituted obstruction of justice, but as far as I know, they haven't actually filed that against her. But it definitely, people have noticed that there's a lot of other issues besides those that were brought before the court.
Yeah, I think whether or not they come to a point of deciding that something more deliberate occurred in a systematic way, I would expect that to be, the hardest thing for them to ascertain, because it would probably take an admission by somebody who would thereby wind up setting themselves up for some time in a stony lonesome. So it'd probably be a little tough.
And we got another question, guys, from Jesse. Are there other individuals pressing charges, such as parents of the students, other school staff, etc., that we know of?
I don't know of any. I guess are we at statute of limitations yet? I think we're probably be. This was we'd be at the statute of limitations. I think we'd know by now.
Yeah, no, I haven't seen anything, and I read through a lot of the court documents in preparation for this and didn't see anything. There were a lot of issues with, especially the school not allowing students to transfer schools who, had developed PTSD as a result of being close to this incident, hearing gunshots, having to run and hide. But I didn't see that any actual claims had been filed.
Good questions.
Yes, both very good questions.
I'll just interject quickly. To the extent that they're potentially minors with claims, the statute of limitations, which ordinarily for personal injury is 2 years, would have expired. Minors, it's until the minor reaches 18. Actually, it's until 2 years after the minor reaches 18, which means potentially there could be claims if there was a minor claim, it could come much later in the process. But adults' claims would certainly be beyond the applicable statute of limitations.
So in essence, instead of dealing with basically 6-year-olds, you could be talked 14 years from 2023 to 2037, I guess, until we're certain statutes of limitations are gone. Fair point. Okay, jumping back into the complaint, the second count was also, as I said, negligence, gross negligence, and reckless disregard for the breach of the duty to inspect. Again, having been warned that there was a gun around, for example, there was a lack of active investigation done to reduce the duties, to reduce the danger, on January the 6th, 2023. And since that one was, that's just directly at the school board. They were the ones with the responsibility, I guess, generally speaking. I don't know why they didn't allege that against any of the individuals, but That was just against the school board. Next one is against all defendants, negligent, grossly negligent, and reckless breach of a duty arising out of special relationships. Now, this is an interesting one to me. Essentially, they were really kind of skating a fine line here, because the special relationship that they're discussing here is essentially that they knew that this child was presenting a danger of harm, but they didn't do enough to protect the danger for her from the danger of harm. And so immediately, as we'll get into later, you start hearing a risk of the employment. And so they had to plead this really, really finely, where they were talking about the special relationship as being something that came into existence only on the day of January 6, 2023, when the shooting happened, when they found out that the child had brought a gun to school, not all the other times that he choked her or slammed her personal property to the ground or did other violent things while at the school. So this was a that the pleading was they took pains, I guess is what I will say, to make sure that they wanted that they were only pleading that the special relationship happened with that, and that the responsibility for protecting somebody from gun violence isn't a risk inherent of the employment in the school district. It's just this one specific kid because they knew that the gun was there. Okay, and count 4 was also against all defendants, and that was a gross negligence, regular negligence, and reckless disregard of the breach in the duty of rising to the violation of the code 22.1-279.3:1, which is a statute specific to school districts requiring immediate notification to the law enforcement authorities if they know of a gun in the school. And failure for that, obviously, anybody who knew that the gun was at the school had breached that statute, and so that was a duty that they considered to be in breach. Those are the complaints. Those are the charges in the complaint, and I think you said there's a question.
Yeah, there was a question from Michael, and Emily, you may have gone through this with or come across this with your review of the facts, and he asked whether there was a school crisis plan that was part of the investigation and or a threat assessment that was conducted on the student previously that was in any of the file material.
Not that I saw, Brian or Justin, I don't know if you read things other than what I read. I primarily looked at the grand jury report, which was really, really interesting, and then several of the court documents. So I didn't see anything, at least that was presented into evidence, about things in that would fall into that category.
No, in fact, this is one of the things I would suggest is kind of in that opportunity lost category there. I didn't see where things like that were presented into evidence either. I feel almost certain something like that exists, because it was just so much in vogue around,
Right.
the last 5 years. It was you couldn't throw a rock without hitting somebody presenting a seminar on how to make your school safe from mass shootings and various other sorts of attacking events. So I think there probably was one, and I think it would have been better had they now here with me with the benefit of being a Monday morning quarterback and knowing the outcome. I can say that. And obviously I think these defense attorneys did a very good job, but I think that was something that would have been better for them. And I think that's probably something they'd admit if you were asked.
And real quick, two attendees asked the same question, and that was whether Dr. George Parker was related to Dr. Ebony Parker. And the answer to that is no, there was no relationship.
That we're aware of. I noticed that too when I was reading over everything and didn't see anything that mentioned a relationship. I assume that a relationship would have been mentioned because it would seem kind of relevant. But I never came across anything that said they were related.
I think we can count on the media to have caught that one for us if in fact it was
right. That's kind of how I felt.
Okay. So what happened next after this complaint was filed was that 3 of the 4 defendants' attorneys, one firm represented all of them, and that is everyone but Dr. Parker, who had her own counsel, filed a plea in bar seeking to have the suit dismissed based on the exclusivity provision of the Virginia Workers' Compensation Act. So here's the code section relevant to this, Virginia Code 65.2-307. which essentially, if you boil that paragraph down, says if you have an incident which meets the criteria for a workers' compensation compensable injury, your rights have to be asserted under the Workers' Compensation Act and nowhere else. That's just, one of those basic foundational things when they made a workers' compensation system, is that you're forced into the system if you fit, if you qualify, and you have an injury that arises out of in the course of the employment. It has to be dealt with within the workers' compensation system in that limited benefits set. And so what happens is if somebody files a suit which arguably ought to be a workers' compensation matter in circuit court, as the defendants here argued, there is a way to very quickly attempt to resolve that issue, and that's called a plea in bar. The plea in bar is essentially saying, let's just take everything that's in the complaint and our answer as factual, and any uncontested facts here, we're going to deem all of the complaint true, and anything that doesn't contest the complaint in the answer also true. And we're going to see if one single legal issue can still determine the outcome of this case. And in this case, that is, even if you take everything as true, is that a workers' compensation claim, and something that should have to be in the Workers' Compensation Commission rather than here in the circuit court. Now, there was also later a demurrer filed, and the demurrer is basically about sovereign immunity. Well, no, actually, I'm sorry, the sovereign immunity was that filed as a plea in bar also? That was a later.
It was.
Yeah.
Yes.
Yeah, I think you're thinking, and we're going to get to it in just a couple slides,
Yeah.
of a demurrer that was filed in a different claim.
Right. There is another
Two plea
claim.
bars.
Okay. Well, anyway, so we've got this plea in bar to deal with right now, which is the one that's particularly of interest when you're dealing with the workers' compensation ramifications of this matter. And so it was filed by the school board, Dr. Parker and Brianna Foster Newton, by their attorneys. And what it says, when you boil it down, is that the risk in this case it should be classified much more generally than what everybody has tried to say. It's a risk of violence, right? Is there a risk that when you're a teacher, the kids who you teach may become unruly and do something violent towards you? And their answer in that plea in bar was yes. And they made a lot of examples there to say, first of all, gun violence is a big problem. There's here's 15 examples of news reports of gun violence in schools with kids as young as 5. And so, they did take that part head on, because of course, the plaintiffs were trying to say, well, gun violence isn't something you can possibly expect out of a 6-year-old kid in a school. So that's not an expected danger of the employment. And that was, the battleground they were fighting on here. When you talk about all those arising out of and in the course of the employment, no real argument about any factor in this case as to whether it would be a workers' compensation matter, except for, did the harm that happened to her, being injured by this student, did it arise as a result of a risk specific to the employment, or is it a risk that's just either general to the neighborhood, or something that's personal to her? Or in some other way, just not an employment risk. And so in their complaint and in subsequent pleadings, the plaintiff made a significant effort to say, and to frame this thing up as a really singular event. This 6-year-old child brought a gun to school and shot his teacher, and that's something that's just so completely horrifying and outside the expectation of normal work that you can't seriously sit here and say that a teacher is risking being shot at school. Because if you say that, and this is one of the things they did actually say in their pleas, if you say that, then our answer is going to be, every teacher in the country is going to tell you immediately, we're not paid enough to be risking getting shot at school. And of course, the defendant said, well, they're already risking it. And here's, as I said, a number of newspaper reports of people getting in the middle of gun violence in school. Here's a number of people getting in the middle of knife violence at school. Here's a number of times where people got injured at school as a result of a student's hands. And they said, it doesn't matter. It's workplace violence. It's not the fact that it's a gun. The fact that it's a gun doesn't make it any more special of a risk than if the boy in the middle of art class picked up a pair of scissors that had been handed to him by the school and stabbed her with the scissors. Um, which obviously I think that would be a case where it'd be a lot harder for a court to deny it because the scissors were put there because of the classroom. But nonetheless, their point was that it is the violence rather than the means of the violence which the court should focus on. And in deciding is it a risk of the employment, whether a teacher may find a student becoming violent towards her, their answer was yes. There's plenty of evidence that that's something that's a part of their job. The court disagreed, and the court really, I would say, they mirrored a lot of the arguments that were made by the plaintiffs in response to the plea and bar and in their complaint. The court focused a great deal on the fact that it was a gun, and again said, this is a case that's just such an unusual risk that you can't seriously say that teachers are ordinarily exposed to the risk of gun violence as an incident of their employment. And then they looked at some cases. They looked at cases about violence against an employee, and they did talk about that divide between things that are personal to an employee as a result of or assaults that are a result of the employment. And I think there was a bit of an analysis failure there by the court to really realize how that is judged by courts. It didn't really look at workers' compensation cases where they had judged this issue very, very specifically and very carefully, but instead looked at a few circuit court cases where the wording was a bit more vague, and came to the conclusion that in using the actual risk, this court does not find that the injury of a gunshot wound is one that is a natural incident of the work or its origin connected with the employment of a first grade teacher, and would not be considered a reasonable person. Would not be considered by a reasonable person as evidenced in the party stipulation that a first grade teacher would not expect to be shot by one of its students. And so essentially what the judge is saying there is that, it's so unexpected that it's not a work incident. And that, again, that's not a proper standard to use in these cases. I think there's been a lot of issue with the applicable standards. And I think he came very, very close to seeing where the right standards were, but he kind of just every time he got close, he would pick out a circuit court case that said words that led him towards this being a civil claim rather than a workers' comp case. And I don't know, is this the appropriate time for me to talk about some cases I think that would have been cited, or shall I do that a little later?
Before we do that, I just want to invite some discussion on this point. And thank you, Brian. That's a good discussion. That plea and bar device was pled early in the case, most certainly long before this case ever reached the jury. And I just want the attendees to understand, at that point in time, the defense was saying this case should be kicked out, should be dismissed because it is a work comp case. And had the judge made that ruling, it would have never reached the jury. And if anyone is interested in seeing the trial judge, Judge Hoffman's written opinion that he wrote back on November 3rd of 2023, 8-page written opinion, we're happy to share that with you. But I kind of want to challenge my attorneys and give some thought because that issue's not finished, right, until we know the appeal period has run. But the defendants in this case have the opportunity on appeal to appeal that finding of the trial judge, whether the trial judge got it right in not sustaining the plea, not sustaining the plea and bar, or not. My personal opinion is that the trial judge did not get it right. I think he should have sustained the plea and bar. The issue with regard to assault cases is clear in Virginia in that if they are connected to the employment, that's workers' comp. If they are connected to personal in nature, that's not workers' comp. I thought it interesting that Judge Hoffman, in his opinion, in part opined, this court finds no cases on point. Um, I'm not sure I agree with that. I think there are cases, certainly not precisely on point, but to say no cases on point, I'm not sure I agree with that. The judge also noted, quote, the risk in this case does not arise from the employment because the nature of the job as a first grade teacher in a general classroom setting does not increase the risk of an injury like the one inflicted by the student. And I don't agree with that either. I think that you look to the motive. There was no personal relationship between this kindergartner and his teacher. The teacher was injured because she had a student in her classroom. He was not a stranger to her. It was in her classroom. She had had problems with him as early as 2 days prior, where he broke her cell phone. My thought is, if this case is appealed, there's a strong likelihood that it will be reversed. And I'm just curious, my other lawyers, to the extent you want to weigh in on it, whether you have thoughts as to whether the trial judge will likely be reversed on the issue of the plea and bar.
I have thoughts, and there are a number of questions pending in the text there that I think we'll probably want to jump into quickly. But let me get it. I want to say, first of all, in 2008, the Virginia Supreme Court in Hilton versus Martin, I think, made it pretty clear. They said an assault arises out of the employment when it is directed at the victim as an employee. Right? They didn't say we have to decide what the means of the assault are and were they weird enough to escape this rule, because they don't care. It's the fact of the assault, not the tool that was used to commit the assault. And I mean, I guess I could talk about this for half a second. I had a case in which a man whose job was welding a metal roof on a silo. He slipped and fell into the silo, and if anybody knows what happens in a silo, the horrible result of that was his death. He essentially drowned in wheat while his welding torch was also burning his leg. So it's terrible, and it's bizarre, and it's the most unexpected thing. And that guy, when he went to welding school, was never given any sort of a warning that one day he might fall into a silo and be buried by grain. But in my opinion, Judge Hoffman's ruling in this case would say that that person should be in circuit court, not the Workers' Compensation Commission. And I can tell you that was a workers' compensation case.
Yeah, and I feel better seeing one of our attendees is the distinguished Scott Fitzgerald from the AG's office. And he says, I agree, this is an assault case and the motive was employment. He shot her because he was angry over his discipline. I think that captures it in a nutshell, and I think you are completely correct.
Yeah, and so aside from Hilton versus Martin, I think the really, really helpful case that kind of controls everything is King versus DTH, which is a 2019 Court of Appeals case. It talks about the fact that it's using a person with unknowable motive, as they call it, but they went through all of the sort of assault process in their opinion. They talk about the fact that you can establish a causal link between the employment and the assault by showing that the employment conditions themselves increase the risk. I would certainly argue you could do that here, but you must show that the employment augmented the probability of an actual assault happening. I think they could do that, but and here you go. You may use the motive of the claimant's assault. How was that motivated by the employment to establish that hurdle? And I think, as the esteemed Squire Fitzgerald just put it, he was mad that he was getting disciplined, and I think it's almost self-evident from the facts and their timing that is exactly what was going on here. And I think that would satisfy the King versus DTH. Their series of tests. I think it would certainly satisfy Hilton versus Martin, and neither of those cases were cited by any of the parties. I think that was, probably would have made this easier for the judge to understand and decide. I think that, the judge would have done a better result here if those cases had been cited. But, there's a lot of cases, and unfortunately.
And so I want to push my panel forward because I do want to talk about several cases that this firm was involved in it with at least some capacity: Hickson, Lopez, and then Crump Gibson. So, Emily, I think you were going to touch on some of those. So I
Sure.
would say let's rip through them if we could so
I
that
will
we can
rip through
take
them
questions.
to the best of my ability. So the first one was a 2007 claim that was decided in Rockingham Circuit Court. And the name of this case is Crump versus Morris. Hoover, Crump, and Gibson all worked for American Home Patient. At some point, Mr. Hoover became romantically infatuated with Miss Crump, and he believed that Miss Crump and Mr. Gibson were having an extramarital affair. He confronted Miss Crump about her belief, was rather verbally aggressive, shouting at her. She felt frightened of him afterwards, but the district manager really didn't do anything. A couple different coworkers had also complained about Hoover's behavior towards Miss Crump, and again, no action was taken. And then unfortunately on May 16th of 2006, Mr. Hoover came to work with 2 handguns, fatally shot Mr. Gibson and Miss Crump before killing himself when the police entered the building. And the decedent's estates filed wrongful death actions against the executor of Hoover's estate, which is Morris, and American Home Patient. American Home Patient brought demurs to the complaint, raising the exclusivity provision, which Brian touched on a little bit earlier. And again, the primary question that the court was faced with in reference to the exclusivity provision was whether the shootings arose out of Gibson and Crump's employment. The employer, American Home Patient, claimed that the plaintiffs failed to specifically allege that the reason Hoover shot Crump and Gibson was purely personal in nature. And so therefore they didn't show the arising out of element. They argued that they were all connected by their employment. It was their employment that brought them together on the day of the shooting. The plaintiffs, argued pretty much this is the epitome of a personal relationship. The shooting wasn't directed at Gibson and Crump because they were employees or because of their employment. It was directed at them because Hoover thought they were having an extramarital affair, and had this infatuation with Crump. Therefore, Hoover's attack on Gibson and Crump did not arise out of the employment, according to the plaintiff. And ultimately, the circuit court agreed with the plaintiffs that the exclusivity provision did not apply, and the civil claim was allowed to move forward. A different result was reached in this case of Lopez versus Intercept Youth Services, which was more recently. And this case was actually cited by Judge Hoffman in his opinion issued in this Werner case. In this case, Lopez was working as an evening support counselor for Youth Quest's independent living program, which was for at-risk youth. Most of the residents in the program had mental health diagnoses, and they'd all been referred to the program from either psychiatric hospitals, group homes, foster homes. Dorsey was 18 or 19 in 2026, and he had a history of violent behavior. On April 16th or 17th of 2016, sometime after 10 p.m., which was his curfew, he appeared at Lopez's locked door, said he needed his medications, and Lopez's job did include the distribution of medications, so she unlocked her door and allowed Dorsey inside. He then strangled her to death, dragged her out of the office, and threw her body in a drainage ditch. And unfortunately, he had the opportunity to do it again. He wasn't caught, and he murdered another Youth Quest counselor just 4 months later. He was arrested and pleaded guilty to those murders after the second one. Lopez's estate filed a negligence claim against Intercept, claiming it had negligently created an unsafe work environment for Lopez. Intercept filed a plea in bar, arguing the exclusivity provision. And as in this case, the primary question was whether the attack and Lopez's resulting death arose out of her employment. In that case, the circuit court found that Lopez was attacked by Dorsey for reasons related to her employment. He took advantage of a spot where Intercept required Lopez to be in her office, and she was responsible for administering medications, and he targeted her because of that. So in that case, the circuit court granted the plea in bar and dismissed the civil suit, and Lopez's estate did appeal. But the Supreme Court of Virginia found the circuit court held correctly, and ultimately, in that case, the decision of the circuit court was affirmed, and so the workers' comp claim in that claim went forward.
And I was involved with this case and worked very closely with Jennifer Parrish, an excellent trial lawyer in Fredericksburg. And I think the court got it completely right in this one. And I predict if the case that we're talking about reaches the Supreme Court, that the Supreme Court will largely rely upon Lopez. I think it has very similar components to the case that we have. Granted, this student, the 6-year-old, was not in an at-risk program, but he certainly had similar components that suggested that he was a troubled child, much like this attacker in Intercept Youth that was part of basically transitioning from a youth program into the community when tragically he killed not one but two counselors back to back.
Right. And Brian has already gone over a little bit the arguments that were made in support of the plea and bar filed in Zwerner's case. But to Scott's point, the defendants in that case, they did try to argue that the child was a special education student. Personally, when reading over the evidence that was actually presented to the court, I didn't see a lot of evidence in support of that. The defendants argued that Zwerner was at an elevated risk in her classroom because of this student, but it didn't seem like it seemed like if that was the case, well, an IEP should have been implemented. There should have been a behavioral assessment. And again, that's part of the problem in this case was certain actions weren't taken beforehand to ultimately try to prevent this issue. But that was something that the defense did raise, but ultimately it was not enough for the plea and bar to be granted.
Yeah, one question was asked, and I think this is interesting. Thank you, Pat, for another good question. But Pat asked if the judge had ruled that this was indeed workers' comp, would the victim then have been able to attempt to circumvent the work comp system by arguing that the employer was so negligent that it caused her harm, in this case, criminally negligent? And I think the answer to that is clearly no, that had the judge found that it came under the umbrella of workers' comp, that would extinguish any potential claim against the employer. Anyone disagree with that? Okay.
I don't disagree at all. One other question that's out there, Penn, is that a comment, yet the school board had a policy about reporting guns. That's actually not just a school board with a policy. That's actually a state statute. And certainly does, I think that does bear some relevance there, but Kristen
did see one of I'm not sure if it was the pleading or the grand jury report where they talked about that and ultimately decided that didn't really weigh in as much because even if that had happened and even if the gun had been reported, that wouldn't have necessarily changed the outcome.
Well, I think the point that the question raises is, well, if somebody bringing a gun to school and shooting someone is so unexpected, why has the General Assembly, in their wisdom, chosen to enact a statute that tells the school board specifically what they're supposed to do in the event a gun comes to school?
Right.
Yeah.
I think that's an excellent point. And again, perhaps an argument that they could have made more pointedly. And so, I like that point very much.
Justin, do you want to talk about the sovereign immunity claim that happened before the civil trial?
Yeah, absolutely. So now we're moving forward into the middle of 2025, the year we're currently in. And at that point, the battle in this ongoing war between both sides in litigation is focused on the defendants. All four of the remaining defendants filed joint pleas of sovereign immunity through the plea and bar system that Mr. McNamara discussed earlier, arguing that Zwerner's claims should fail because they would be barred by the doctrine of sovereign immunity. As our friends on this call who work for governmental entities know very well, sovereign immunity protects the state and its agencies and its employees from liability for tortious personal injury negligently inflicted, but it does not extend to claims of gross negligence. In the process of this plea and bar, the plaintiff elected to voluntarily exercise her non-suit of right as to a claim in count 2 against the school board only. So at this point, the defense has gotten one of the 4 defendants out, and one of the 4 claims is out of the case as well. The court additionally granted summary judgment for the defendants as to counts 3 and 4, which means now there's a single count and a single defendant left in the case, and that would be Assistant Principal Parker. The sovereign immunity, generally, the standard there is the standard for gross negligence in Virginia is one of indifference and not inadequacy. Very clearly, a claim for gross negligence must fail as a matter of law when the evidence shows that the defendant exercised some degree of care. So we're talking about just doing something, showing that you've done something to try to prevent the harm that ultimately occurred. Ultimately, the case went to civil trial in late October of this year. I guess I skipped ahead on the slides. Must fail as a gross negligence claim must fail as a matter of law when there is evidence that the defendant exercised some degree of diligence and care. The Virginia Supreme Court decided the case involving a Boy Scout who unfortunately drowned, a teenager. There was a claim in that case from the 2016 Supreme Court case of Elliott, the administrator of the estate of Smith versus Carter, that there was a claim against the Boy Scout leader. And ultimately, the Virginia Supreme Court found in that case his actions were not so insufficient as to constitute the indifference and utter disregard of prudence that would amount for a complete neglect for the decedent's safety. As the slide says, post that Elliott case, it doesn't take much to defeat a gross negligence claim. You just got to be able to point to something. And the attorney for Dr. Parker said, look, no one could imagine that a first grader would bring a gun to school and shoot their teacher. Conversely, the attorney for the plaintiff, Ms. Zwerner, said, who would think a 6-year-old would bring a gun to school and shoot their teacher? It's Dr. Parker's job to believe that this is possible. It's her job to investigate it and to get to the very bottom of it. So, with a single count against a single defendant in which the plaintiff had to prove gross negligence, the case went to a multiple-day trial, and I think Scott was going to talk about the verdict itself.
Yeah, before we do that, Justin, I'd just be interested in your impressions. Do you think there's any vulnerability to the ruling on sovereign immunity in this particular case? In other words, any chance we could see a reversal on that topic from your perspective? And do you think there's any implications? Does this move the needle for you on the sovereign immunity law?
So I personally don't think that it moves the needle. I think that the facts of this case, as addressed by Emily at the beginning of this, were painted to be so egregious that it appears that based on all of the evidence that has been publicly reported in this case, it would seem that the jury found, and before that, the circuit court judge found, look, there is actually no evidence in this case that Dr. Parker did anything, that she was, to use the Supreme Court's language, indifferent to the situation. So I never fully confident in what an appellate court may do, but I'm not sure that this will get as much traction as perhaps, say, the workers' compensation exclusivity issue, Scott.
Right. I agree.
Yeah.
I think, this case, before I really, when I was just looking at the media coverage, I had some questions about well, what exactly did Dr. Parker do or not do? And then when I read the grand jury report, she really did nothing. I mean, she was given every opportunity to do anything to at all prevent this situation. And I don't even think this is a matter of hindsight's 2020. I mean, she was told by students, like, I've seen a gun that this student had. I've heard, and they had this other child who was visibly shaken after he said this child showed him a gun, and still Dr. Parker did nothing. I mean, it was really just beyond what anyone could imagine or hope that, an administrator would do when faced with this information. So I agree. I mean, I think this is, Justin mentioned earlier, it's not hard to defeat a claim of gross negligence. And this was one where I think it would have been hard to defeat that because she really didn't do anything.
Yeah, and I think the facts were pretty egregious as I learned them related to the actions of the principal here. So the verdict, I watched the closing. What's interesting to me, my recollection, and correct me, my colleagues, if I'm incorrect, but I think plaintiff's counsel asked for 40 million. Is that right? Asked for 40. Yeah, they're not. He asked for 40 million. And what was interesting to me, it was not done like you often see plaintiffs do, where they sort of identify, this is towards medical, this is towards pain and suffering. They just asked for a number. And the jury deliberated not terribly long, 6 hours over the course of 2 days, and came back with $10 million. And so I'm curious, my colleagues here, what your reaction is to the damage award, and Justin, certainly interested in your thoughts. Justin does an excellent summary for us at our annual seminar talking about top verdicts in Virginia, and has his finger on the pulse with regard to what we generally see as nuclear verdicts and outliers in Virginia. Where does this stack up for you to start, Justin?
Yeah, absolutely. Thanks, Scott. I mean, so by definition, this was a nuclear verdict, right? Because it was 10 million plus. As far as how does this stack up in Virginia, if Virginia Lawyers Weekly always publishes at the end of every year the top verdicts and settlements. We have information for 2024. Obviously, we're currently in 2025, but just to place it in context of what we know occurred in 2024, if this verdict had come down in the year prior, it would have been the fifth highest jury verdict in Virginia. So we're not a venue that typically sees verdicts like this, but you have the right set of facts from a plaintiff's perspective, from the defense perspective, the wrong set of facts. Go in front of a jury. Newport News is considered to be one of the more liberal venues within Virginia. So it's a significant verdict. It is not an unprecedented verdict in Virginia, however, but it is certainly significant, and it is a verdict that plaintiffs' attorneys will be pointing to moving forward to scare defendants and defense attorneys into, you need to put more money on the table or risk, a verdict like this.
And we're bumping up the end of our allotted time, but I do want to try to get the questions answered. And thank you, audience. Wonderful questions. But Michelle Dacey asked, my concern is that this goes beyond this case and impacts assaults by students. I work in education, and this is exceedingly common. Sad commentary, but I agree, right? Particularly with students who have IEPs, 504 plans. I can't help but wonder how much the severity of this situation impacted the case on the whole. I agree with you. And, judges and appellate judges are people, obviously. And it's more challenging, I think, for them to take it away once it's been granted. But I still think there's an excellent chance of reversal with the issue of the plea and bar. But I'm curious from my panel's perspective, but I suspect that we'll see the plaintiff's bar bringing many more of these assault cases through common law, trying to bring a civil claim before they move towards workers' comp. And it's sort of a teaching point for our adjusters is that be mindful when you're looking at the work comp case. Don't look at it myopically just from workers' comp, but recognize that if there's potential liability, you may want to be thinking the case should be accepted rather than denied because of the 307 bar. Others have any comments about that?
And aggressively. as in if the case comes in and plaintiff's attorney just comes and says, well, we're not going to file this as workers' comp, don't just put it aside and say, oh, this is somebody else's problem. So, well, maybe you may want to say, oh, yes, this is workers' comp, because we would rather have $125,000 worth of medical bills and indemnity checks than a $10 million verdict. In particular, this is an amazing test case for that principle, because one thing that was amazing about this verdict of $10 million is that Mrs. Werner, although shocking in the event and the sequence of all in the aftermath, she wasn't hurt that bad. She had a bullet pass through her hand going to her shoulder. They got that out of her shoulder, and her arm is relatively back in full function. In a
She
workers'
did have
compensation,
6 surgeries and was in the hospital for 2 weeks, and the bullet's still in her. But no, I
right?
agree. I was going to kind of bring the same point up. Like, she went to cosmetology school after this. She's no longer teaching. Like, she is still able to, have a somewhat normal life. Certainly not
Well,
seeking
I
to
mean,
do
her
what she went through
her
at
her
all.
arm is as I
Right.
understand it, she's reached relatively full mobility in her arm. So they would you have to pay for a bunch of surgeries? Yes. Is there, maybe 150, $200,000 in medical bills? Absolutely. Is her indemnity probably going to be limited to about 2 years? That'd be my guess. Is there going to be a permanency claim? Maybe, but not a very big one. So, ultimately, you probably look at this workers' compensation case from a, very far off distance on the back of the envelope calculation as $300,000, maybe 350.
And that's part
And
of why I think ultimately the jury awarded 10 million as
oh
opposed
no,
to 40.
right, but I also think that's why, the judge, if he's a sympathetic person or whatever. I think one of the problems is that, if you have any knowledge whatsoever of the workers' compensation system, you look at a case like this, which is incredibly sympathetic. She was
Right.
treated horribly.
She was
And you
25 when
say,
it happened.
if I dump this lady into the comp system, she's not going to get very much money at all. I mean, her bills will get paid, but that's not for her. She's not going to get very much money in her pocket at all. And she probably should have. It's a, what I guess, like in the Wild West, you used to have those, the SOB had it coming kind of outcomes in trials. Um, I think this is almost kind of the same way. This is the SOB school district has this coming, and rather than basing it on the facts and the law, I think they were just sort of said this is the wildly disparate impact of this being a comp case versus being a $10 million or whatever, a much more less restrained civil verdict.
So, Brian, if I could follow up on that, please. I absolutely agree with that. I do believe, it appears to me that the jury did want to punish what they perceived to be a bad actor. And what I'm looking at there is the fact that there was apparently an award of prejudgment interest. Now, on a 6% on a $10 million verdict, I believe it ran, if I'm not mistaken, from January 1 of 2024. So you've got a year of interest on $10 million. That's a significant, I believe that's a significant amount of money in the civil litigation context with civil juries. In my experience and sort of the conventional wisdom is, Virginia juries historically have not been prone to award jury or prejudgment interest unless they're sort of inflamed against the defendant and feel like, look, you've held on to that money that you weren't entitled to for too long, and we're going to make you pay interest on it as part of the verdict.
And
So I
so
agree with
last
you.
last point on the slide, which I think is of interest, is that the 10 million should be paid for by the Virginia Risk Sharing Association, which is an insurance pool that's made up of public bodies statewide that included Newport News. And to our knowledge, there's been no appeal filed. Um, any guesses, team, whether we think an appeal will be forthcoming? Any thoughts about that? And we're about 6 minutes over, so I do want to stop, hard stop in about 2 or 3 minutes.
Both parties originally said they anticipated this claim going all the way to the Supreme Court. So I'd be very surprised if somebody does not appeal, but nobody has as of now.
By way of clarification, I want to say I had talked about the plea in bar that was filed by three of the four defendants. I took another look into it because I was just struck with the idea that if Dr. Parker didn't jump in and make a similar plea in bar, she was possibly going to box herself out of the possibility of doing so. It appears that about a week or two after they filed their plea in bar, she filed a kind of a Me Too plea in bar. So she was covered by that decision by Judge Hoffman that we discussed, and so she would have appeal rights into that. And yeah, I think the prospects should be pretty good. The Court of Appeals, I don't think, would even be able to allow this thing past them because of King versus DTH.
I do want to mention briefly, Pat asked if Abby filed a claim and were workers' comp benefits paid. So a workers' comp claim was not filed by Abby, but it was actually filed by the school board on her behalf. And it was filed even before an interlocutory appeal of the denial of the plea in bar was allowed. The school board said, and the defendant said, they filed it in order to preserve her right to file a claim within the statute of limitations, since she hadn't filed one. Whether that's their only reason, their actual reason or not, that is what they said. But one was filed, but not by her.
Any last final comment from anybody on the panel? All right.
There was a question that was presented by, I think, anonymous attendee that was about whether or not this would go out of employer's liability versus going out of general liability. And I don't think this does wind up going out of employer's liability. I have yet to determine what in the world actually would come out of an employer's liability policy. It's that little thing that's at the tag end of a workers' compensation policy in form 000000 under
There's an insurance pool
part.
that the school is part of that
right.
is
it is
who's going to be paying it if it's paid and if nothing else happens procedurally. But
right, it is a GSIA. That's correct. But I mean, I think the question is just which insurance line specifically would this thing get hung on? And I don't believe it would hang on the employer's liability. I think this would go into the general liability.
Okay, well, thank you. Let's wrap this up. But Emily, Justin, and Brian, thank you all for your wonderful participation. John, thank you for your assistance.
Thank you, attendees, for some really great questions.
Yeah.
Yeah, and attendees, thank you. And I do want to tell folks we are recording this presentation. If you think your colleagues may be interested in it, just reach out to us. You can reach us through www.fordrichardsonlaw.com. We're happy to provide you with a copy of the video today. If you're interested in our newsletter, our electronic newsletter, where we update folks on the state of the law in Virginia as well as North Carolina, feel free to similarly reach us through the website. We will let folks know as we do additional webinars. We do these obviously pretty frequently, but I also want to just tell folks we do have a date for our 25th annual, believe it or not, workers' comp seminar next fall, September the 16th and 17th. So mark your calendars early if you would. The 16th is the liability portion, and then the 17th is the workers' compensation portion. But we look forward to some surprises in a particularly special program since it's our Silver 25th program. But thank you all for joining. We really appreciate your attendance, and we wish all of you a very happy holiday. Thank you for joining.
Bye. Thanks, everyone.
Thank you all.